Hi everybody, and welcome back. This is Tim Franczyk once again from the Assigned Counsel Program, here to talk to you about matters of law and evidence. First of all, I'd like to say that I hope that everyone is doing well, feeling well, making the best of these confining circumstances. Hopefully we'll be able to get back into circulation before too long. Today, I thought I'd speak to you a little bit about expert witnesses. I've selected this topic because I feel that there are very few trials these days that go forward without some input from expert witnesses. For example, if you're trying a homicide case, there's a pretty good chance you're going to hear from a medical examiner to talk about cause and manner of death. Or if you're a personal injury lawyer, and you want to establish the nature of the injury that the plaintiff sustained and its causation or relation to the accident, then certainly you're going to have to call an expert in orthopedics and perhaps even biomechanical engineering, as the case might be. You can't try a gun possession case without calling a firearms examiner to testify that the weapon in question is operable. Or if you have a murder case or an assault case where there's a shooting involved and you want to show a connection between the ballistic evidence found at the scene or retrieved from the victim and a particular weapon, you're going to need a ballistics examiner to show that particular connection, that the projectile was fired from this particular weapon. Or if you're going to try a drug case, there's a good likelihood that you're going to hear from a forensic chemist to talk about testing of the substance to verify that it is a controlled substance, cocaine, heroin, whatever the case might be. Or if you have an accident case, there's a good chance one side or the other may call an accident reconstruction specialist or expert to talk about how the accident happened, by examining the crime scene or the accident scene, looking at the skid marks, the damage, the crush damage, all those kinds of things, applying certain principles like coefficient of friction to estimate speed based on skid marks, all those kinds of things. In some cases, you might have a blood spatter analyst to offer an opinion as to the nature of the force of the blow that caused the injury, that caused the blood to spray on the wall, as opposed to blood that drip down on the floor. So there are so many different possibilities for calling expert witnesses, and it requires lawyers, I think, to be familiar with the rules that permit expert witness testimony. And the first thing is, or one of the first things to consider, is that you have a properly qualified expert. An expert can be qualified in any number of ways, by virtue of skill, knowledge, education, training, and experience. Those are very common ways. But it doesn't have to be necessarily highfalutin experience. I mean, it's nice if you can get an expert with an Ivy League degree and a nice CV or resume that talks about all the teaching that this person has done and so on and so forth. But it doesn't mean much of anything if that person is not a good teacher, is not a good communicator, someone who can distill the complicated, make it simple, and then convey it to a jury. So when you're selecting an expert, you want to find someone not only who has a good pedigree, who has the gravitas or the chops to testify about the subject matter in question, but also is able to get it across to a jury in an understandable and hopefully likable way. I'm reminded of a scene in one of my favorite movies, The Verdict, with Paul Newman. And the trial in that case involved a malpractice action against a hospital and a doctor and an anesthesiologist because the plaintiff went in to deliver a child to give birth, and they gave her an anesthetic within 1 hour of her having eaten, and it caused her to vomit or throw up in her mask. And she basically suffocated and suffered near brain death, irreversible brain damage. And in preparation for the doctor's testimony, James Mason, who played the venerable defense lawyer, is doing a mock direct examination, and the doctor's got this shock of white hair and a resume that was as impressive as could be. In fact, he wrote the textbook that most of the doctors used on anesthesiology, and he was talking about what happened and said, well, that the victim had aspirated vomitus into her oxygen mask, and James Mason basically slapped him in the face. He said, "Did you mean to say that she threw up?" "Yeah, that's what I meant." "Well, for heaven's sake, then say that. Speak English." So the point is, pick an expert who can communicate in everyday terms, but nevertheless have the academic and experiential background to make it sound like it means something. So you have to pick someone who's qualified. And that doesn't mean, for example, that you can have an officer, police detective, who's attended many autopsies give an opinion on cause and manner of death. That's for the medical examiner. But on the other end of the spectrum, think of My Cousin Vinny, where Marissa Tomei was an expert in various aspects of auto mechanics, not based on education, but on life experience. She grew up in a family of auto mechanics, and she was one herself. So she was in a position based on experience to give an opinion about, I think in that case it had to do with tire tracks and wheelbase and things of that nature. So there's any number of ways that an expert can be qualified, but he or she should be testifying within his or her pay grade, within his or her area of expertise. So choosing the right expert is critical. The second part of it is, maybe this could be the first part, is that the subject matter has to be appropriate to expert witness testimony, meaning that it's beyond the range of knowledge and everyday experience of the average Joe and Jane juror. It's not something that they can deduce from life experience itself. So, for example, if the question is what happens, let's say you have an auto accident case, and the question is, well, what happens when somebody puts their foot down on the brake pedal? Well, you don't need an expert to tell you that the car's going to slow down and come to a stop. And if you hit the brakes really hard, it may leave a skid mark on the highway. However, if the issue is whether or not the brakes on this particular vehicle were defective, then you'd probably need someone like Marissa Tomei to come in and give you an expert opinion on whether or not those brakes were defective. So it has to be an appropriate subject matter for expert witness testimony, meaning that the topic or subject area calls for the expertise of a properly qualified expert to help the jury, assist the jury understand the issues in the case and resolve those issues and come to a conclusion. So they need an assist, a help to come to a conclusion that can only come from an expert witness. So it's got to be appropriate subject matter for expert witness testimony. A couple of cases that are oft-cited when it comes to the expert witness rule are People versus Inowa, I-N-O-A, 25 New York 3rd, 466 from 2015, and an older case of People versus Cronin, 60 New York 2nd, 430 from 1983. Now, a threshold question that you should always have in the back of your mind when you're dealing with experts who are testifying about matters of new and novel science, newfangled science, or new ways of coming to conclusions or studying things, and that's Fry versus United States, 293 Federal Reporter 1013. It's a DC Circuit case from 1923, and New York State still adheres to the Fry rule when analyzing the threshold question whether or not an expert can be allowed to testify based on scientific principles and methodologies that were applied to the case at hand. But it's important to keep in mind that if an expert is testifying based on his own personal testing, own observations, training, and experience, independent of any scientific tests or theories that are out there, Fry doesn't come into play. And if you're dealing with an established matter of science, such as DNA, blood alcohol content, testing, principles of physics underlying accident reconstruction. You don't get into Fry, and you should resist any efforts by opposing counsel to have a Fry hearing when it's not called for. It's when it's a matter of new and novel science. And what Fry tells us is that under those circumstances, the proponent has to show that the underlying scientific theories, principles, methodologies have received and enjoy general acceptance in the relevant scientific or professional community. All right? And that's a separate question, which is the next question, separate from the admissibility, which is whether or not those principles that are relied upon were properly applied in or applied to the case at hand. That's a basic question of admissibility, and it takes more than the experts say so to testify, oh yes, I properly applied these principles to the case at hand. There's got to be independent evidence. But the Fry question is the threshold question when you're dealing with matters of new and novel science, and New York is one of the few states that still adheres to the Fry standard. A New York Court of Appeals case, which is worth keeping in mind when you're dealing with Fry issues, is People versus Wesley, 83 New York 2nd 417 from 1994, and People versus Adone, Oddone, cited at 22 New York 3rd 369 from 2013. That case stands for the proposition that if an expert is not drawing upon scientific principles and theories and methodologies, you don't have to get into this whole business of general acceptance.